All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
We are in open session, Mr. President.
Thank you.
Thank you, Your Honours. As just stated, the prosecution formally requests that the present witness, witness 516, be declared hostile. The prosecution submits that it is apparent from the witness's evidence thus far that he has deliberately and systematically departed from his prior statement to the prosecution. He has resiled from almost every incriminating aspect of that statement, and our respectful submission has been unable to provide a consistent or credible reason why he has departed from his statement.
You mean incriminating in the sense of evidence that would tend to incriminate the accused in this case?
Indeed, Your Honours, incriminating evidence for use in the present prosecution, the reason for which he was interviewed and called as a witness. Obviously, he is a witness who has not been cooperative with the prosecution. He's refused to testify voluntarily and had to be summoned before the court. He's also refused to consult with the prosecution in witness preparation prior to his evidence. As to his demeanour, Your Honours, I submit that this witness has been extremely evasive, far more evasive even than the previous two witnesses in my submission. The transcript is peppered with examples of this, but I refer Your Honours to transcript 142 from pages 27, line 22 to page 32, line 14, when I asked the witness questions about the atmosphere amongst the ODM and PNU supporters and amongst the Kalenjin and Kikuyu in his area. Your Honour, I submit also his his demeanour has been generally hostile to the prosecution. He's been uncooperative, and for all of these reasons, I submit that there is more than adequate grounds for the Chamber to make the formal ruling at this point.
Ms. Beisman, Mr. Hooper, who goes first?
Well, it's going to be us. Thank you, Mr. President. It's interesting to hear the application of my learned friend. And the first time I stood up to make my application, to dismiss the application for hostile witness in the first instance, the first witness, he told me it's like we are coming from a different courtroom, and I feel that's the same situation. I do feel we've been sitting in a different courtroom. When my learned friend says he's extremely evasive, I couldn't disagree more. I think this has been a witness who's really tried to answer questions. There's been misunderstandings, that's for sure, but to say evasive, the least. But let me start with, I think, the most important point of your decision. Before you go into the criteria that were just pointed out by Mr. Steinberg, you say that the application founded upon a complaint of hostility, and I quote you, is an instrument of justice to the effect that without the remedy being sought, a criminal trial may never get at the truth. Well, we have yesterday given an alternative that was dismissed by the prosecution. We have suggested we can go on with this witness, we can allow you to cross-examine him, and so there is no need in this particular situation to make this application. You've heard us 2 days. We've been relatively silent, especially the Sang team, but also the Ruto team. We've basically made no objection, and there's been lots of leading questions. So, first of all, there is really no need, and on the basis of your decision, this is not a situation where such an application should be made. But going through your criteria, the first is the general.
But what perhaps Mr. Steinberg might worry about, he hasn't said this, why he did not accept your offer, was that the offer came with a qualifier that the ICC may ask leading questions until the point that the defense objects. What is he expected to do with that? If you say, yes, we can, let's pass up the opportunity for the court to declare a witness hostile and give the prosecutor the right, as it were, to cross-examine and ask leading and closed questions. But then you say, well, but you do that because of giving you the license, which we may take away anytime he suits us. Would you accept that if you were in his position?
Well, Mr. President, I'm surely not suggesting that we're waiving our right to object to leading questions as of now. But I think if you look at what has happened until now, he's been able to go through the statement. He's gone to the witness has given his explanations. The explanations are not the ones that the prosecution wishes to hear. But there's not been a situation where he couldn't go further with this witness. He said what he said. And as I said, until now, we've barely made an objection, and we have conceded that we will even allow further and let him go through the statement and put certain propositions to this witness. Where appropriate.
The point is, are you insisting on your earlier offer that yes, he may go ahead and ask leading questions until you say no, he may no longer ask leading questions?
Yes, although I think now there is an application that we're responding to. So I think that's now moot.
Perhaps not. If you made your position clear, then he will have an opportunity to react to it. He started to say that he wasn't prepared to go at your sufferance. That's the point. He wasn't prepared to go at your leave. He wants to have the right to cross-examine the witness and ask those questions. So so it shouldn't be a matter of a privilege he's enjoying because you've allowed him to enjoy that privilege. That's the concern.
Well, I'm in a difficult position. We are prepared not to object. At the same time, that should not be a waiver full stop. It also depends how he's going to go about it.
All right, then.
So maybe we just go on with this application and
yes,
we don't get in a difficult situation later on. The 4 criteria. First of all, we are dealing with a general demeanor of hostility. And the second one is an impression of evasiveness on the part of the witness. I'll discuss these two jointly. Well, obviously, we have some difficulties to even assess the demeanor because we're dealing with someone who's speaking in a different language. There's been difficulties in translation. My lead counsel stood up from time to time. Not always, because we don't want to interrupt the proceedings. There's been difficulties with video transmission, and also both teams have made that point. Sometimes it's hard to see him, sometimes it's not. So there's been difficulties, I think, in general, to assess the demeanor of this witness. But even with these difficulties, it's our position that he's not presenting himself in a hostile manner. He did give immediate response to the subpoena. He was very nervous, as we heard him say, and I think it was already addressed by my learned colleague from the Ruto defense. he had a meeting with the VW, and he even expressed his desire to start his testimony a day late, which was not granted, but he was here, he's been here, he's answered all questions from all sides. The prosecution says he's not cooperative because he didn't want to speak to them prior to the testimony. Well, that too, in our submission, is not at all a sign of non-cooperation, because he's been, in general, he's been polite to everyone, and most importantly, he's, unlike the other two witnesses, he has not incriminated anyone from the prosecution side. Because that was a very strong argument on the other side in earlier applications, that he was implicating and was making serious allegations against the prosecution. He hasn't done that. And in fact, it's been put to him. Mr. Steinberg did ask him the question, was it the prosecution or was it a third party? And he said, no, it wasn't the prosecution, it was a third party. So I think that's very important in terms of cooperation. Also, we've had some discussions about his statement that was taken without an interpreter, and it seemed to be the suggestion on the other side that he has no difficulty with his English. And Mr. Steinberg put it to him, you've gone through your statement before you came to testify. The VW gave you that opportunity, and that statement was in English, was it not? And he said first of all, he said he had complained because it was too short a time span that was given to him to prepare. And second of all, he did say he was provided with an interpreter. So it's clear to us throughout this testimony that his English he's not very comfortable in English. And I hear from my Swahili-speaking colleagues that his Swahili is really good. He does feel very comfortable in Swahili. But then there is the translation.
We are in open session, Mr. President.
Yes, Mr.
So essentially, yesterday I was, for our part, offering Mr. Steinberg, as it were, an open and unimpeded road for questioning. But the question as to whether this witness truly qualifies as a hostile witness is not clear-cut. It's not clear-cut as the previous witnesses have been, one of whom probably could stand as a definition of adverse. But this witness hasn't trod that path at all. He's given an account. There were and has been undoubted departure from what he told the prosecution in his original statement. Or as we'd normally put it, he has not come up to proof. But not coming up to proof should not entitle the calling party to have him qualified and categorized as a hostile witness because of a failure to come up to proof. And when one looks at this witness in the round, we find that he speaks of induru, of screams, of smoke and fire and houses burning, of people fleeing, of pillage of cows, and the rest of it. So in terms of general crime scene evidence related to Turbo, this witness, in fact, does conform factually and does not depart from what one would gather was the situation. In other areas, right from the beginning, for example, he was asked, how did Mr. Ruto become a leader? And he said he didn't know. And when one looks at his statement, he tells us that he became a leader because he was anointed as such at Kipchoge Stadium. And he thinks that was in 2002. Well, we know that's not right. We know that's wrong. And that therefore, when the witness says, "I don't know now," when one looks at his answer to the prosecution, we can see that he didn't know then. And then it goes on through the particular aspects that the prosecution anticipated his evidence would deal with, or at least at one time did. And he's resiled now from membership, or claims he was not a member, as we know, of a particular group, a role that would have given him, of course, the basis and motive for doing certain things. We know that he's spoken about his political membership. I don't think there's been a departure there. He says that there were meetings at Mr. Ruto's place, and just one moment. Now, I was just ensuring the witness wasn't within earshot of what I was saying, and of course he isn't. And we see that as far as the meeting at Mr. Ruto's place, you can see in his statement that he talks about them being held on 3 consecutive days. We know that's not the case. We've had previous evidence of that. He's wrong about that. He's wrong about that. And when we see the meeting at Farouk Kibet's home, which he says he attended in his statement, he says that was untrue and he didn't attend. And there's a departure from that in the context of his phoning 326 in order to report. And a meeting in Beshapur.
Isn't the test, Mr. Hooper, about, quite apart from whether or not demeanor displayed hostile animals, or whether the witness has been evasive, but on the test of extensive degree of departure or divergence between testimony and statement, isn't that what we're looking for? You bring the testimony, you bring the statement, and you look at both of them to see if there has been a departure. Isn't that the test? Does it matter whether the witness was right or wrong in the prior statement?
Well, it's an aspect of it, because, as it's already been said and we can observe, this witness has given an explanation for his departure, while at the same time asserting to you that he's telling the truth. And hostility is in part a finding that the person that, in respect of whom the calling party seeks to have declared hostile, that party is undesirous of telling the truth. Now, I agree with the comment that was made in your decision that places you in perhaps a situation you should not be seen to be in. We are not a judge and jury where a judge can make a finding of fact like that, but the issues go to the jury, and there's no issue of prejudice arising as a result of a finding of fact by judges of untruthfulness. I understand that, and you categorize, therefore, this application as being undesirous of telling the truth according to the calling party. And I accept that is an appropriate criterion to apply, and to be applied in that way. But the problem here, isn't it this, that the prosecution is saying, the prosecution say he's undesirous of telling the truth. But they can't put their finger on what the truth is. I bet they can't even tell us or prove where he lives. Because the very basic investigations of seeking corroboration for this witness, as with many others, it hasn't been done. And indeed, that was part of the motive that we heard this witness express for his reason for saying certain things, that he knew that he wouldn't be found out, or at least it was a risk worth taking.
Well, Mr. Hooper, 2 minutes to round up.
So it really comes to this. The prosecution are really saying, well, we have a concept of what the truth is. And we'd like this witness, in fact, declared hostile so that we can assert it to him. But they do so, in part, without a proper basis. And I said at the outset of my submission, in a way, we offered the open road yesterday to the prosecution. And it really is an issue of the propriety of calling this witness hostile and the particular circumstances in which he gives his evidence. But the objective of the prosecution, as I understand it, is to put Article 70 material. We don't stand in the way of that because there isn't really any substance to it. All the Article 70 material will show is what you will find and see is a very, very worrying threat made by OTP investigators to this witness that unless he cooperates with them and comes to them, they're going to disclose his name. That is quite a shocking, shocking process that we're going to see. And I don't mind you, the judges, seeing it. But the problem is that it doesn't actually advance the prosecution's case. And so where we're going on this, the extra material, as it was, that they've got to put to this witness, isn't the kind of material that you saw previously with the other witness.
Excuse me, did you actually say that there was a threat made to a witness that unless he cooperates, his name will be disclosed?
Yes.
Which is quite incorrect, Your Honours. I will explain in due course.
I may have put a particular shine on it, but in all seriousness, you'll see that that's effectively what happens. What the investigators say is this: something terribly serious has come up. You're at risk. You're at increased risk. We can't protect you where you are, i.e. in Kenya. You're going to have to come out. But if you don't come out, then all we can do, and will have to do, in fulfillment of our duties, is to ask the Kenyan government to protect you. That's how it's played. And you'll see that. I put no shine on that. So that was all in pursuit of Article 70 material. I can understand the motive for it, because they wanted to put perhaps this witness in the same position and hold and grasp as they did the last one. But it doesn't depart from whether it's an appropriate threat. But that's where we're going. And I only mention that. I mention that because that's the nature of the evidence. We're not going to, as it were, find here the kind of material or conversations that we heard in respect to the last witness. We're not going down that road. But
right, we will leave it at that, Minister.
Yes.
Thank you very much, Mr. President, for this opportunity. We support the prosecution's application. In our observation, the manner this witness answered the questions posed by the prosecution meets most of the requirements Your Honor set on the 8th of September. We know three things, Your Honor. Firstly, in our observation, this witness has been evasive. We can cite many examples, one of which this witness has been answering questions using very generic terms. And prosecution counsel, in our observation, had to repeat his questions several times in order to get a specific answer from this witness. Secondly, Your Honor, We also note the extensive degree that this witness has departed from the main points of the statement he had given to the prosecution's investigators. Your Honor, there has been some issues whether this witness has acknowledged certain facts, but Your Honor has established in your decision that the departure can be in whole or in part. Of course, the issue whether certain homes were burned or not, that's a matter of public knowledge, Your Honor. The fact that he acknowledged, certain properties were burned or destroyed, that's not a matter of dispute. But the real dispute is who is responsible for those destruction. Thirdly, Your Honor, we also note that this witness appears to be deliberately impugning the prosecution's case. The defense counsel argues that he didn't, in fact, accuse the prosecutors in
offer to benefit from protection. As it transpires, the witness turned us down in that connection. So in my submission, Your Honours, this witness has clearly departed systematically. He's not simply forgotten to mention certain aspects of his evidence, as other witnesses who might not come up to proof may do, but he's positively asserted that he lied to us, and lied to us with a particular purpose which fits in with the broad scheme of the defense allegations. Your Honours, as to my learned friends, for Mr. Ruto's submissions that we don't have the smoking gun, as it were, like we did with the last witness, well, that is true to some extent, and it is also true that my cross-examination beyond the scope of the statements will be more limited than the past witnesses. But there are still some important matters which I need to explore, particularly the reason for his now recanting, which I wish to put to this witness, and one or two other matters. But I don't expect it will be very long, but I do need to do it, Your Honours.
We will adjourn and come back at 11:30.
All rise, veuillez vous lever.